You're live. It is April 21st and Senate Judiciary. We are taking back up S329. We started the walkthrough, got about, I think, halfway. I believe we stopped at section 3. But you have let down from here to pick up where that, that's here.
Hi, good morning. Eric Fitzpatrick with the Office of Legislative Counsel. Here, as the chair said, to continue to walk through S329, which is an act related to criminal procedures involving firearms. As chair indicated, I think we had gotten through section 3 last time, but
sorry, I meant markup, not walkthrough. Yeah.
Oh, right. Sorry, I did too. Right. Yes, marking up the bill, and if I remember correctly, the decision of the committee last time was to take out section 1, which was the provision related to increased penalties for larceny of firearms. I didn't hear any changes to section 2, which was the enhanced penalties regarding second or subsequent offenses for persons prohibited from possessing firearms because of a violent crime conviction. Or committee may have still been reserving judgment about whether to include that section as well, but no change that I heard of yet. It's more of a in or out. The same with section 3. This is the provision that involves one of the other prohibitors that exists both in federal law and in state law. That's often called a mental health prohibitor. Certain people, if they have been subjected to involuntary commitment, either under federal law, that's upset that exists, and in fact, federal law is broader than that. Apply to such situations where the person isn't necessarily dangerous. For example, they lack mental capacity to make a contract or manage their own affairs. In other words, like more of a guardianship position situation than a dangerous one. So that federal prohibition is much broader than what is proposed here, which is only for persons who have been found dangerous to themselves or others as a result of a court proceeding. That's the proposal that you see in front of you in section 3. I should again remind the committee that in terms of the language, not necessarily the policy here, that the Department of Health has been in touch with me, and they may have a suggestion or two about how to tweak this language. But we haven't been able to circle up yet. But just to let you know that that's sitting out there, and I'll report back to the committee once to find out what the proposal is from them.
And was that for line 5 as a subject of a commitment order?
Yeah. So you're on page 7?
Yeah.
Yes, exactly. It's in there. It might be, I don't know exactly what their suggestion is. It might be for the, something that applies to the entirety of that subdivision that starts on line 20, page 6, and goes over to line 10, page 7.
So we'll try to hear from them soon.
Also in section 3, that has the same provision. This is page 7, line 70 to 18. That's that same idea that you talked about with respect to the felons in possession language, violent criminals possessing the second or subsequent offenses. The proposal is to make that a felony. So parallels the proposal in section 2 for convicted of violent crimes. So that brings us to section 4.
Hold on 1 second. So Mindy, are there any questions or recommendations for section 3 that we have it right now, or I mean, we're still going to hear from CMH, but
yeah, secondary, we're just going to have a larger conversation about misdemeanor to felony for those.
yeah, I think we touched on that a little bit last time.
Yeah.
I think we can't remember exactly where the conversation went, so we just wanted to pause for that. But what are people's initial thoughts?
Probably want to be consistent, right? They need to the different sections.
Yeah.
What do we want to be?
Well, there are 3 or 4 felonies added here in this draft
to the,
Because I know we looked at two last time. This is a third one.
Yeah, the first one.
The first one was section 1, right?
Yeah,
Yeah.
and then I thought there was one before this.
oh yeah, section 1, section 2, and section 3. Yeah, so this is the third of the 3.
Right. So I suppose I would want to consider them all separately because in general, I take the point about not wanting to add felonies. But I do think in some of these cases, the one where somebody has been convicted of a violent crime and then they twice broken the law having a gun, I do think that should be a felony. But I'm of two minds about this.
The one on 7 you're talking about?
No, I think it's section 2.
Yeah, page 2, line 18.
Yeah. So you've been convicted of a violent crime and then you're not supposed to have a gun. You have a gun, you get a first offense and that's not a felony. But then if you get a second time with a weapon, it's a felony. That makes perfect sense to me because violent crime, not supposed to have a gun and you twice violated that. So,
I think, 1 second, I think I'm more comfortable with keeping section 2, but I do have different thoughts about the third felony that we're having on page 7, lines 17 through 18. Because it's a bit more complicated in that section with the mental health aspects of it. But, haven't landed on a firm position yet, but Senator Host could.
Well, my concern is our definition of a violent crime. My concern is that we consider sharing drugs a violent crime.
sharing drugs.
Yes, so on page 5, beginning on line 8, a violation of 18 BSA, selling, dispensing, or trafficking, and then we list a bunch of drugs, and dispensing is simply sharing. And so my concern is not so much with the underlying idea that if you've been convicted of a violent crime and multiple times have been illegally in possession of a gun, it's how we define violent crime.
I think it's other than. I think we talked about that.
That's the same thing.
For instance, violent crime means the list of, if you turn to page 4, list of crime is defined in subdivision 530 of this title, other than. And then on page 5, it lists the just selling and dispensing. So it's other than those.
Okay,
actually, or those are included.
okay.
So the other than's, the excluded, I know it's a little hard to follow because of the Roman numerals. But the exclusions start on page 4, line 9. So those are not included. One, in Roman numerals all the way up to, those are on page 4. So Roman numeral 1 through 6 in capital letters. So those are excluded. Those don't count for violent crimes. But if you put capital letter A on page 4, then turn over to page 5, these are included. Capital B, sexual exploitation of children. Capital C, those drug crimes.
Now, wait, where's capital A on page 4?
Wow. Line 7.
Yeah, line 7. That's the listed crime. So capital A is listed crime except for. Right. That's what.
It's A, little I, and then page 5 is 2 little I's.
Yeah.
Okay.
It is drafted in a way that is a little difficult,
Well, because
but I do follow
different
it now.
categories, you had
Yeah.
to break them out. But yeah, so subdivision A, think of that as
So bottom of page 4.
Yeah.
Leaving the scene of an accident is or is not?
it's not
Okay.
excluded.
And then,
Didn't we run into this issue with stalking? I remember we changed the definition to say that stalking was a violent crime. And then there was a Supreme Court case. And the Supreme Court said, just because the legislature says that an offense is violent, but it doesn't actually contain elements of violence, doesn't make it a violent offense necessarily. Is that
For purposes of the Constitution, I think the court was taking the position that in that case, it was because the violent crime language is in the Constitution around bail. And the saying the legislature can't define it, but it's a constitutional provision that's first court. In this case, it's all statutory.
So in other words, Eric, on page 5, C, what Senator Zahoski is talking about,
Yeah,
C and D are violent crimes, but they're violent because it's connected to drug use.
right. You got it.
So it seems like we could make a decision to remove those two sections, but keep the felon.
I would be okay with that.
So if we were to do that, what other areas of law would that affect? What ripple, I know maybe too soon to ask that question, but you know, I'm curious about bail. Any initial thoughts on any ripple effects or unintended consequences if we were to remove C and D, or is that something we should come back to?
I think it's a good idea to come back to it to be sure, but sort of my first impression is that this is a very confined use of this terminology. So it's only what violent crimes are for purposes of this statute prohibiting firearms. So I don't, off the top of my head, don't see any ripple effects, but I would want to ponder this to be sure in case I'm in the moment missing something. I'd also add that what I'd also want to look into is that these offenses only count as prohibitors. In other words, the violent offense for purposes of prohibiting a person possessing firearms. It looks at line 15 and 16. If the offense prohibits the person from possessing a firearm under the federal prohibition. And so I'd want to double check on that and just see what is the federal prohibition, just so that just for clarity, just so we know that cross reference is referring to.
Any other initial thoughts or comments on? But I guess the question is, do we remove C and D, or do we remove the felon, or leave it untouched? So I guess those seem to be the three options right now. Are there any other thoughts or recommendations for that?
Are these under C, are these felonies? The offenses themselves?
Also something I'd want to follow up on. I think the answer to that
I was
is
gonna say
yes.
trafficking probably is, but I don't know that selling and dispensing always is.
And it's also, you notice that I haven't reread all of the details of this for purposes of today. But I think that if you see the cross references, for example, the first one on line 8, 4231, which is selling, dispensing, packing cocaine, B2, B3, or C. I'm pretty sure that the intent of that was to capture the felonies only, because there's a B1 I think is a misdemeanor. This tracks only, remember, didn't see those cross references. I want to follow up and be sure on it. So I think the answer to your question is that it's just going to be yes, it's felony. But it's a definitive answer, I'll confirm it.
I guess the other thought to keep in mind for this one though is if somebody has been convicted, well, so these offenses in C and D, you have to be convicted of these offenses before the felony on page 2 would kick in, right? Or the misdemeanor.
Correct, exactly.
So I guess the other question to this is, would we want to allow, if somebody is convicted of trafficking cocaine or heroin, to be exempt from getting a potential misdemeanor if they are later found with a firearm after they've been convicted of the felony trafficking offenses? Is a question of the end.
I think the other option, rather than fully striking section C, would be to strike the references to selling and dispensing and human trafficking.
I'm not sure I understand what you're suggesting.
So I think that another option, rather than striking C in its entirety, would be in all the instances where it says selling and dispensing, to strike that and simply leave trafficking.
Uh-huh. In other words, trying to go for the bigger,
I don't know if that would accomplish if that would accomplish it. I mean, if you're trafficking, you're also likely engaged in selling too. Whereas the dispensing aspect could just be two individuals sharing.
I think, again, want to double check on the language, pretty sure the trafficking, they're keeping the amounts. So that someone might sell, but not necessarily be trafficking, if they aren't selling a significant enough amount. Agreed. I think it's right. But again, I'll come back to you guys with the exact amounts that trigger each offense. Because you may want to think about how you want to credit this if you want to make changes.
Any other thoughts, folks? Part of me that is more inclined to leave it as a misdemeanor, but we can revisit that. All right, so we'll mark this as a decision point regarding the felony section. Section 2. And that brings us to section 3. So this was the section, so we step back, this is the section where we mentioned DMA is going to come in at some point in the future to help tidy up the language or correctly do the commitment. And that's, I believe, on page 7.
That's right. Exactly.
And so I guess we're just going to the same question as before, which is if somebody is caught a second time carrying a firearm, they fall into this category, should they get a felony?
On page 7, I can say line 7, 8. So it's a fair law provision, the one that you just looked at in violent criminals in possession. So same question.
and am I right that we talked last time about how it was only during the duration of the order?
Not always. That is the case for page 7, lines 5 through 10. So if it's a situation where the commitment order did not involve a violent crime, then yes, only for the duration of the order. But if it did, then so if you look at page 7, lines 1 and 2, if the not guilty by reason of insanity verdict involved a violent crime,
Yeah.
then the prohibition is current, which is the way federal law works.
Mhm.
So in that sense, subdivision 1, subdivision 2 parallel federal law, whereas Romanet 2 and Romanet 3 are narrower than federal law, because those folks are only prohibited during the pendency of an order in those situations where that distinction doesn't exist in federal law. If you fall under this group in federal law, the prohibition is permanent unless you go through that relief from disability process.
I mean, that seems relatively nuanced to me in a good way. So I see where the House landed on this. So I could support this as written at the previous section for the new felony for the.
So we're talking about someone who may have been found not competent to stand trial due to a disability, so they may not understand the legal proceedings. And it seems to me, higher penalties for someone who is on an order like this because they don't understand the system is a little problematic. But yeah, that just is my initial thought. I don't really have a question. Other
By
than
higher penalties, you mean the second or subsequent offense?
yeah, because we're talking about someone who maybe doesn't understand the legal system, doesn't understand, like, because, and that's why they are found, you know, incompetent or.
Any other thought on this?
Well, I understand what start both these kind of things. But if the individual committed crime to begin with, if he or she's not competent to stay in trial, in my mind, has to set the issue itself.
If they're incompetent to stand trial, they haven't been convicted of a crime. They're incompetent to stand trial and they're not able to stand trial because they potentially don't understand the system. So I feel like increasing a penalty on someone who already doesn't understand the system, like they're more likely to make a mistake because they don't understand the system.
I guess I mean, there's a couple different paths because, you know, there's not guilty by reason of insanity of a violent crime. That's defined in section 4017. And that includes, are those the offenses on page 5?
Yes,
Yeah, okay. So,
4 or 5. but
4.
Yes, yeah, that's the better reference.
and so they're not guilty, reason of insanity. And so they, and that also includes the exceptions. It
Correct.
doesn't include the exceptions.
That's what, no, it does. So
So if they're not guilty by reason of insanity for reckless endangerment, then they can be charged with a felony for a second offense.
And I think that's an exception, so they would not be.
they were charges.
Not the, okay, so that's what I want.
Yeah.
And I'm not suggesting that this group of people should be allowed to have firearms. I just think if we're talking in some part about striking out the felony for someone who fully understands the legal system theoretically and has been convicted of a crime, we should also be having the conversation about someone who is not capable of navigating the system.
Not capable of navigating the system, but keeps getting it done. Which to me is very worrisome.
I just don't think we should be increasing penalties for people who maybe don't understand the system if we're having a discussion about not doing that for people who do.
But I guess what I'm saying is if we say this person doesn't understand, so we're not going to increase penalties on them. If they get caught a second time, it'll just be under the misdemeanor offense. I don't know. It seems like the system at that point needs to take greater care with that person. Because they have a pattern of getting. So first of all, there was a violent crime. So it's the 3 thing, right? Violent crime. Now twice they've gotten the gun when they're not supposed to. I just don't think you can turn a blind eye to them when somebody keep getting a hold of the gun when.
So I guess then the underlying question though is what would charging them with a felony accomplish?
Well, it does allow you to hold them longer. If the court feels that they're a danger.
Any other comments?
I understand what Senator Bruce trying to say, but, you know, charged with a felony is not the same thing as being convicted of a felony also, that to keep that in the discussion. Allowing somebody to, was committed a serious crime, but not competent to stand trial. A still happened before B does. The serious crime versus the not competent to stand trial, whereas they could be, if they're taken to say a forensic facility someplace, and they are restored in competency, so on and so forth. So it's six, this half of dozen the other, yes, I don't think we'll look at it. But, like you say, okay, so second offense, you don't say, oh, well, you can't stand trial, we'll give you a gun still. Yeah.
But I mean, to the chair's point generally, I think you were arguing the other day that increasing the penalty for a second offense to a felony in your view of it wouldn't moderate behavior anyway. So it seems like that's the underlying issue in all three cases is there any benefit to society to have graduated penalty system?
Senator Norris, were you in support of keeping this felony, or do you want more time to think on it?
Well, I'm, very prepared as far as to talk about the dispensing, selling, or traffic drugs. That's I guess, how we're going to proceed with that before we look at, part two of this. And it would be my quest.
Senator Madden?
I could really go either way, because I see it both sides of the coin. So I guess first here, DMH a little bit more about the other two might help narrow down my thoughts on 1, 2. Yeah.
So the other concern I have, in addition to there being very little evidence that stricter penalties deter crime, one thing there is evidence of is that longer prison sentences are associated with a higher risk of reoffending. And so, when I think about taking care with people who are incompetent to stand trial, it's about treatment and care, not putting them in the carceral system. But I'm also happy to wait to hear from DMH. So just ready about sort of uncomfortable with the increased penalty in this instance, especially given that it links back to 5 that includes all of that language around selling and dispensing. But I know we're going to come back to that later. So this is they're all linked together for me.
All right, so we'll mark that as our second decision point. And I think the previous decision point was the other felony that we were talking about earlier. So but I think there's more questions lingering for this decision point than we said rather than the previous one.
And just as we leave this, for me, the strongest is section 2, the violent crime, because there's no mitigating circumstance there. So
I agree. So that takes us to section 4. Yeah, that takes us to section 4.
Yeah, so moving on now, we've got the decision points noted for sections 2 and 3, and I'll come back with some further information about the applicability of the violent crime definition and the different amounts of drugs involved. And I think we've got DMH can also provide some information on how that language works. So moving on to section 4, this is the piece that is maybe parallel to federal law. So you've got federal law that prohibits possession of machine guns. And that language, if you look at page 8, lines 13 through line 20, that defines a machine gun. And that is verbatim the federal definition. So it's making a Vermont offense for possession of a machine gun the same way as prohibited under federal law. However, there are provisions under federal law that allow, under certain circumstances, for machine guns to be possessed. So notwithstanding the general, they have to be registered if they're possessed, but they can be possessed as well. For example, so the one that was possessed prior to this federal prohibition going into effect in 1986. So if you had one legally at that time, when it became effective in 86, you can keep it. So that you didn't know that was a provision of federal law. So, however, if you still have it, you have to register it. So if you look at the language, bottom of page 8, over on the top of page 9, the term does not include any weapon or other item that is registered in the National Firearms Registration and Transfer Record maintained by the Bureau of Alcohol, Tobacco, Firearms, and Explosives. So if you have a machine gun, if you come under one of those federal exceptions, you can have it, but you have to register. So that's how this parallels that federal piece as well. So in other words, if you're permitted to have it under federal law, then you'd be permitted to have it under this Vermont provision as well. And there are certain circumstances in the very last clause, top of page 9. So if there are certain circumstances under federal law when you don't have to register, so if it's not subject to that registration requirement, remember, I think you guys heard from witnesses a week ago or a week or 2 weeks ago about how for certain developmental purposes or experimental purposes, or other times if someone has manufactured a gun, they will actually submit it to the Bureau of Alcohol, Tobacco, and Firearms, and they'll look at it and decide whether or not it's a machine gun or not, whether it meets the definition. And if the answer is no, that doesn't have to be registered, that would also not be prohibited under Vermont law. So the idea is to totally parallel the federal prohibition. It's prohibited under federal law, prohibited under Vermont law.
Which means you don't need federal agents if you want to arrest somebody or charge somebody. You do it with the state.
Exactly.
Yeah.
Yep.
Any questions or recommendations? Questions? I don't have to think for it. I'm fine with it as it's written. Okay. We can move on to the next section.
Right. So the next section, section 5, has to do with the possession of firearms on premises licensed to serve alcohol. The proposal here is to prohibit firearm in those areas. So this is part of the sensitive place exception to the Second Amendment. You may recall, we talked about that in this committee before, as the United States Supreme Court has said that there's a long-standing history of permitting the regulation of firearms in certain sensitive places, for example, legislative assemblies, courthouses, that sort of thing. Vermont law has both of those prohibitions. There's also prohibitions on hospitals, polling places in Vermont law currently. So this proposes to add another location, and that location is premises licensed to serve alcohol. So you see line 13 and 14, page 9. Person knowingly, in other words, you have to know that you have it, and you have to know that the premises is a place where alcohol is licensed to be served. If you know both those things and you have the firearm anyway, then that would be the prohibition. And it's a 1-year misdemeanor. See that lines 15 and 16. So it's 1 year maximum prison, $1,000 fine. Then you have a number of carve-outs, number of exceptions that go from the bottom of page 9 over onto the top of page 10. So, for example, a second-class licensed premises, that's a place, for example, convenience store, grocery store, or someplace where you buy alcohol, not for consumption on the premises, but to take away and drink at home. So prohibition doesn't apply there. The second one, you'll see lines 20 and 21. This was originally came out of the discussion in the Senate Government Operations Committee last year when it was considering the prohibition specifically related to the city of Burlington's charter. In this case, it's a statewide prohibition. In that case, it was only applied to Burlington. But the issue came up, which you see described in lines 20 and 21, which is what about situations where there's a public sidewalk that goes in between the licensed premises, for example, just as an easy way to sort of visualize what this exception applies to. Think about Church Street, and sometimes there's some tables that are right flush against the side of a restaurant, that sidewalk goes in between, and then there's some more tables outside that are roped off. All those premises are licensed to serve alcohol. So without this exception, technically speaking, someone walks through that sidewalk. My understanding is that's included. You carve it out here and say, well, the sidewalk or public highway that passes through an outdoor premises for which the licensee holds an outside consumption permit, it can't be prosecuted. So it's an exception.
Eric, one question I had that maybe we covered this already, but parking lots that are adjacent to or owned by the bar or restaurant, whatever it might be, are those considered premises?
Generally, no. If for some reason in a particular, trying to think of ones, there may be some places where they have tables in the parking lot and that's part of the licensed premises that could in theory be covered. But it's all, my understanding is the license very specifically plots out the areas that are covered by the license. Generally speaking, it's not just going to be a parking lot unless, as you say, I'm trying to remember if there's some places that have picnic tables or whatever in the parking lot. But it would have to be described in the license as part of their license premises. Otherwise, just a parking lot that's not part of that would not be covered. So you could leave it in your car, for example. Let's see, turning to page 10, so let's see other exceptions. Certain, and C&D, or you actually see is one of the certain other types of permits, limited event permits, special events, that sort of thing. Often referred to, for example, as a farmer's market or something like that. Someone might be passing through with a firearm. This doesn't apply in that situation. There's a very specific carve out to subdivision D dining car for which there's a promotional railroad tasting permit. There sometimes when you have ability to buy drinks on whether it's fall foliage tours or tours from Burlington to Virginia's, Middlebury, that kind of thing. So that wouldn't be affected by this either. And then lastly, you see sort of the boilerplate exceptions in subdivision 2, which this committee has seen many times in its firearms law generally. That apply to law enforcement, military, other government officers or agents who are acting within the scope of their duties. One that is specific to this provision, you'll see lines 17 and 18, page 10. That's the holder of the license for the premises. So generally speaking, that's the owner, but not necessarily, but generally going to be the owner, provided that that person is not prohibited from possessing a firearm under state or federal law. So if that person can legally possess, then they wouldn't be prohibited by this either. There's a posting requirement. See that on page 10? It's also similar to language that you have in the hospital, hospital buildings statute, for example. There's a posting requirement. Has to be posted conspicuously at each public entrance. And that's broken down, but substantively, that piece as well.
Thank you. Committee, any questions, comments, or suggestions for this?
My only comment was that I'm disappointed you didn't borrow the language from 1853 that firearms were prohibited at all balls and permit goes. Yes.
Something for a minute.
Legitimate comments.
Any other recommendations or suggestions or questions? Okay. Let's go back to the relinquishment language. Is that the lengthier one? That's everyone was saying we do have amendments on.
Mr. Chair, is this an amendment from you?
Yeah, the relinquishment language.
Oh, okay, that's where you're going now.
Yes. Okay. So we should all have that. So this was language that we already got a walkthrough on from Carolyn Hansen, and it was not included in S 329, but it was something that we'll have to consider adding to 329. And so, Eric, did you kind of give us, it's similar to what we've been doing with all the other sections? We could do that for this amendment as well.
Yep, absolutely. So again, as Jared mentioned, you had the first round of a walkthrough from Carolyn Henson of the Attorney General's office on this language. And just to remind the committee, you may recall that in the miscellaneous bill last year, this was a study committee, a working group task force that was created by the legislature last year. to address this exact problem, which was not to change the situations under current law where firearms sometimes have to be relinquished, which does exist already, whether it's related to a relief from abuse order or an emergency risk protection order. ERPOs, those already require relinquishment of firearms in certain situations. So the idea was to come up with a consistent process for what happens when a firearm has to be relinquished. And that's what this task force wanted to study, and they came back with some proposed legislation and some recommendations, and that's what you see in the language practice, what the task force submitted to the legislature December, I believe it was. So the big picture is that these procedures are created, and I'll walk through some of the there's also you'll see on page 1, line 4, 20 VSA 2301, there is statute in place already that has to do with how firearms that are relinquished have to be dealt with. And I immediately saw the first change that would need to be made, which is right there on line 5. But the way the statute is titled currently is just firearms relinquished pursuant to relief from abuse order. So the substance of the language goes beyond RFAs and involves ERPOs as well. So you would at least want to add ERPOs there, and you may want to even just change it to so that you would have to change it every time. You just see, relinquished firearms, something like that, or relinquished pursuant to court order, something general is an option there as well. So in any,
Where were you suggesting that?
lines 5 and 6, the title of the statute should also be changed to be consistent with whatever direction maybe decides to go. So I'll note some of the differences that are proposed between current law and the language here. That'll also provide a discussion of how the process works. So the first one on page 1, you'll see line 18. Current law applies to ammunition. So throughout, ammunition is struck. Storage of ammunition is difficult. The task force concluded, and it's not regulated the same way as firearms are, so it really should be included. Generally speaking, so how would a firearm be relinquished? It can be relinquished to a law enforcement agency or to an FFL, a federally licensed firearm dealer, or you'll see on page 2, line 9, after a hearing.
Sorry.
Yeah,
Sorry,
just before we go too far, Eric.
Yeah.
I'm looking on page 1,
Yeah.
line 13, definition, law enforcement agency, state police, municipal sheriffs. But that is meant just for this bill, the way that it's written here, because obviously we have more than.
Exactly. You're exactly right. Yeah, only because in other places it's defined more broadly. Yeah, you got it.
I assume that's meant sort of limit someone perhaps walking up to a forest warden and handing them their gun. Like why is it this limited? Do you have any, I guess that's not really a question for legislative council, is it?
Well, not at the top of my head. It could be that looking into, this language where it came from, we might be able to come up with an answer, but possibly not. But yeah, sort of looking at it, you'd have to conclude that it was specifying the agency, because this is only for purposes of having an agency store your firearms. Yeah. So it's probably wanting to be for that specific purpose, specific about who it is, which agency is stored.
Yeah, that makes sense.
All right, so as I was saying, you can store it with the person can store it if the court order comes in, they can store it with the agency, they could store it with a federally licensed firearm dealer, or, and this is page 2, second sentence there, lines 9 to 11, can also be stored with a third party. If after a hearing, the court finds that the alternative relinquishment, and that's a phrase that was used in the underlying statute as well. It's an alternative relinquishment, not to law enforcement, it's not to the FFL, to a third party, but the court first has to have a hearing and find that alternative relinquishment adequately protects the safety of the parties. Now that's a slight difference from current law, in which a hearing is not required and the court can just go ahead and order that relinquishment to a third party. Unless, and that's lines 15 and 16, the struck through words, unless the court finds that relinquishment of the person will not adequately protect public safety. So kind of shifting the burden a little bit. You've got to have a hearing first and find that safety will be.
is it, this might be a question for Judge Zone, but is it possible to just combine the hearings into one rather than having a second hearing after the first? So, somebody who's going through the ERBO process, they're at their hearing, and if there is going to be a relinquishment of their firearm, then they bring that witness or that third party, and presumably they'll testify and be asked questions, and the judge can make a determination there rather than creating a second hearing. I mean, it puts the onus on the individual to have the forethought that if their firearms are going to be relinquished to a third party, they're going to have to bring that third party to that hearing, the first one to begin with.
I think certainly as a matter of writing the language, it's certainly doable. But here, I think I've raised the exact correct question, which is for the judge. Because you can certainly write a sentence that says the court may consolidate the hearing required under this subdivision with the hearing required under the RFA or ERPO statute. You can certainly do that. But it does, question for the court is that practical? And then the question you want here is, and it would be related to the language at the bottom of page 2, which says that the final relief or release hearing or the ERPO hearing shall not be continued solely for the purpose of approval of a third party. Interesting, that sort of applies to that it has to be combined. Yeah, right. Yeah, right.
Sorry.
I have a question, Eric, about page 1 at the bottom of the relinquishment. It says a person who is required to relinquish firearms. And then flip over, upon service of the order, shall relinquish to cooperating law enforcement. And it says, as used in the subdivision means anyone who meets the definition of intimate partner or who qualifies as a family or household member or any person subject to an extreme person protection order. Is that in the sense of on 5 and 6, person also means anyone who meets those definitions? Or is person limited to someone who meets the definition of intimate partner, household family member, or subject to an extreme person protection? You see what I'm asking?
Yeah, I think it's limited to those folks because those are the people that would be subject to the order. Or one of those orders.
Okay, so
So in general, it's an intimate partner who would be subject to the RFA or household member.
I'm just thinking relief from abuse order. And then over there, an extreme risk protection order.
Mhm.
So if somebody was subject to a relief from abuse order, does this eliminate them? Or are they held?
No, they're
in another part?
if it's subject to the order, then they would be the person who has to relinquish.
Yeah. Okay, I'm just getting hung up by on line 5, page 2. It says person, it defines person as only these 3 things, which doesn't include relief from abuse.
No, that's relief from abuse is 6 and 7. So those are folks who can get who would be subject to the RFA.
Okay,
So a family or RFA is against another family or household member.
okay, so
So if you're a family or household member who has an RFA against you, then you could be required to relinquish your firearms. Same way if you're a person who's subject to.
I just keep getting this confusion. On page 1, person refers to the person who needs to relinquish the firearms. But then on page 2, it seems like person means somebody who is asking for the order.
I know, and I got hung up on that too. I'll double check, but I remember looking at this because that terminology also refers to the person who's subject.
Okay,
Yeah.
if you don't think there's any confusion there.
I know what you mean, though. I initially got hung up on the same thing. I'm doing this backwards, but when you look at the statute, it's actually,
Okay,
that's the person who the order is against. Even though I know what you mean, when you see the term intimate partner, you think that must be the person who got the. Which it also is.
it just seems like there's two definitions of person that are in the same section,
Right,
meaning different things.
right.
Anyway,
I'll double check to make sure there's not anything inadvertent happening there. As far as the consolidation goes, question to look at, I think, and think about whether or not, because you think about, the ability of the firearms owner to find a third person, or as the statute uses the term, an alternative relinquishment. Then a certain process has to be used. That's the bottom of page 2. Firearms shall not be held by a third party unless approved by the court using this process. Go over on the next page. And then it specifically says that the hearing, the RFA hearing and the ERPO hearing can't be continued solely for the purpose of approving a third party. In other words, for the court to try to find whether or not a third party can hold those firearms. However, there is a little bit of process there. If you look at over on page 3, if the court is unable to accommodate hearing from the proposed third party at the hearing, or if the defendant is not prepared to present the third party, then the defendant may ask for that later on. The defendant may file a motion using an approved form by the court to request a hearing at a later date on whether the third party should be permitted. So there is an option there. But in the first instance, the way the language is written doesn't allow the court to continue the hearing, specifically to be looking for a third party who might be equal to partners.
Well, I'm concerned about.
I was just thinking, what happens in that interim period where you're waiting? Because you haven't had that hearing yet for the third party. Does law enforcement or FFL have to then hold that?
I think so. Yeah, I think at least the law enforcement is they've seized it. Then either they're going to have it unless they give it to somebody else temporarily, like an FFL.
Fair enough.
So what if they're there, they get the restraining order and says you must vacate the premises, and you do. And then the other person says, no, those are our firearms. So I don't need to relinquish those. I have ownership of these firearms also. How's that work?
Yeah. So like a co-owner,
Yeah.
right? If there's a provision that allows that, but it's an interesting question.
well, if the confusion I was talking about is real, they would be included in another person.
David, let's assume for the sake of the hypothetical that there's another owner who's not subject to the order. Like maybe the order is only against one of the family members, you know, but the claim is, well, no, we both want that, right? An interesting question.
And the second person will not have to go through the background check because they're on possession of this firearm, right? Or the court procedures.
It's an interesting question that I want to circle back with. What is the procedure, if any, for a co-owner who's not subject to the order? But good question. All right, putting a pin in that one.
Yeah.
All right, so a third party generally, though, has to agree to a background check if they want to be, that's over on page 3, Romanet 3, line 6 to 10. So to be considered as a third party, you have to agree to go through a NICS background check. And then that result is provided to the court.
So Eric, again, another question for zoning most likely, but can't the judge check 29C triple I from the stands? And I know they can see a person's background. I don't know how deep it necessarily goes in terms of what they have instantly available.
I don't know what the judge would have right from the bench.
I'm just, the reason I ask is because whatever process gets created, I'd like it to make sense you know, somebody, if a person is there in the courtroom and the judge can look at their background and make a determination as to whether or not they're prohibited or whether or not they can hold these firearms, it just makes sense to do it at the same hearing rather than saying, okay, third party, drive to an FFL, get a background check, and then have the FFL transmit those to the court, and then we'll come back in a week or however long. I just wanted to be
As efficient as possible.
Yeah.
Right.
I agree, they're being charged, it's only nice, he's gonna go on with it. It's not right there,
Yeah, so. Yeah, all right, so I guess that's the question.
Right? Next couple of pages are really just technical corresponding language. It brings you over to page 5. There's an acknowledgement form. So this creates a form so everyone knows once the firearm is relinquished, everyone knows who has it, where it is, and the court is going to be the ones developing this form. Then the form is filed with the court or law enforcement or both. So again, the information is on record as to where the firearm is.
Under the acknowledgement form, I see where abuse prevention order and extreme risk protection order, so it doesn't pertain to temporary relief from abuse orders.
That could include all, because it's the entirety of the chapter. I'll get to in a moment that these temporary orders require an extra level of process before they're going to be covered by these. But if person agrees to it and the temporary order is covered, then yes, it'll be covered by the form as well. Okay, 5. So we just talked about the storage process through third parties, that's alternative relinquishment. Then over on page 7, there's subsection G. This is about storage with FFLs. The law enforcement can also store with FFLs. So if you look at lines 5 and 6, if the agency doesn't have the capacity to store, or if they don't choose to store non-evidentiary firearms, then they can store it with an FFL. If, this is lines 10 and 11, they have to provide notice to the person, the owner. That's where it's going to be. It's going to be at an FFL. And this notice that they provided the owner has to include certain information, that the defendant has a responsibility to keep the FFL informed of any address changes, that they're going to be responsible for paying costs, etc. So that's all going to be in the notice. Over on to page 8, this notice that I was just describing can be provided directly to the defendant from the FFL, as long as they keep a record of it. So the FFL can provide the owner with notice about where it is, how they get it back, that they have to pay the storage fees, etc. The enforcement agency does have to provide certain information to the dealer if they choose to go that route, and you see that in subdivision 3. That's line 7, page 8. So that law enforcement agency has to let the dealer know the name and of the owner, contact information, the docket information about the court case that's going on, and any other information about changes to the case if the dealer requests it. Now this gets back to your question, Senator Norris. This is subdivision 4, line 16, page 8. These are temporary orders. Now what about because these are all final orders that we've just been talking about, but they could include a temporary order if, and you see that on page 8, the general rules that they're not going to be relinquished pursuant to these temporary orders unless, and that's line 19, unless the defendant chooses to have the dealer hold the firearms and agrees to pay storage fees that accrue while the temporary orders in effect. So the defendant has to give consent specifically in order for that to be held relinquished pursuant to a temporary order. Over on to the top of page 9, there's the victim notification provisions. If these firearms are held and released, then the victim has to get notice, or at least there has to be reasonable notice. Reasonable efforts to provide notice to the victims. Again, if an FFL is holding one of these firearms, also page 9, lines 15 through 18, before they return it to the owner, there has to be a background check. So they have to, and that, my understanding was that that's just current practice as it is. That's correlating the statutes with current practice. Now we're talking about what happens if the person doesn't retrieve their firearms. And in this case, there has to be a reasonable effort to provide notice to the person that they're supposed to come get their firearms and that they could be sold, because that's what could happen. They could get sold if the person doesn't come retrieve them. And then that's over on page 11. That's part of the existing statute as well. That's not new. That's an existing statute. One thing that is new, you'll see this is line 6 and 7, page 11. That if there's a sale, and this happens when the person hasn't claimed them, there's have a right to get them back, but they don't claim them, then the dealer or the law enforcement agency can sell them and then retain all proceeds. That's line 6 and 7. Under existing law, if there's any excess from the costs that the person paid, and if the seller there's excess, then those costs are supposed to be returned. Area on that.
One thing for you, if a third party, so not an FFL, not a law enforcement agency, is holding somebody's firearms for them in this context, and years go by, the defendant disappears, never hear from them again. Is that third party ever going to be able to sell those firearms if they don't want to hold on to them anymore?
That I don't believe is addressed in specific.
I do want to make a note there that somebody, if somebody abandons their firearms with a third party, and that third party makes a reasonable effort to get back in touch with them, however, whatever the length of time could be, if they don't want to hold on to them anymore, if they're moving, they have a way to get rid of them without having a problem necessarily. Or rather, without getting sued by the
Right, so think about how to add basically the third party storage first.
So yeah, third party storage charge? I don't know if I heard that part. Charge a fee, storage fee.
I don't think so.
It's not required, I think. So, but I suppose if the two people could agree.
Yeah, I'm thinking, and maybe I'm wrong, but I'm thinking the third party would be selected by the person who's having to relinquish, right?
Yeah.
So their friend, Chris. Oh, sure. That was a very hip ringtone.
I didn't know people still had it's great.
So in other words, you pick your friend or somebody who lives at the end of the road who's sympathetic. They pass the background check. They're holding the weapon for you. So it doesn't seem to me like it would probably be an issue, but maybe that's not why it's addressed, because it's somebody who's sympathetic to the owner of the gun, or at least it's agreeing upon request of the owner of the gun. But it's a good point. If the person disappears, are they required legally to hold the weapon indefinitely?
Yeah, I think there could just be something there that, if they want to, if the defendant disappears and they're holding on to this firearm, they could, after a certain amount of time, sell it.
So that's that.
Yeah. Or just
Not
Could
their
they-
firearm,
another person.
Not their firearm.
Could they just?
Well, after a certain point, it's considered abandoned. I don't know what that point is.
Eric, under this language, could they relinquish it to an FFL at that point? In other words, just say, I don't want to profit from it, I just don't want to be holding it, so here, take it.
I don't think they necessarily would be prohibited from doing it but I don't think the FFL would be required to take it either.
Yeah, and why would they want to if the person's disappeared?
Maybe
Unless they
to
could,
sell it. Could they keep it?
I mean, if it's abandoned, the defendant abandons it with them.
How that, would they have to go to an FFL and do a transfer? And how would that transfer work? If it's an abandoned firearm?
Yeah, I don't know. I mean, I think if it's legally relinquished to them under a court order, you know, they have possession of it indefinitely. But then, you know, let's say 20 years passes and they're like, I don't want this gun anymore. What happens to it?
They already had to have the background check. To take possession of it in the first place. So if they just kept it, didn't transfer it to anybody else, there wouldn't be a transfer that would trigger the background check.
But they wouldn't own it either. Wouldn't you have to have transfer done then?
Well, that'd be an interesting question. It could be that you, and I don't know, I'd look into this, you know, perhaps you could just say that after whatever the period of time is statutorily, that it could be treated as abandoned property. That may be an option. I have to look into.
And does that require going to an FFL and doing a transfer, so to speak?
I'm not looking into that specific question. Don't recall it ever having come up before.
If it becomes abandoned property.
Yeah, because like becomes abandoned property, then you have it. Do you have to actually go have a transfer done and do the transferee and transfer or or in that case be abandoned and then you're the transferee?
Well, that already on record though, because I had to do the FFL check on that individual prior to getting the gun, so that already done. Well, my question is, so if you maintain them, that's one thing, but if you choose to sell them to somebody else other than an FFL, how does that come into play?
Well, you certainly couldn't do that without going through a background check. So there's two questions. There's a background check question, and does the person even have an ownership interest? They can just sell it to somebody else if it's purely because they've been holding it and the person who owned it never showed up. So that's probably a question of property law, question of abandoned property. But yeah, they couldn't transfer it to another person without a background check. Or maybe they could hold on to it themselves since they already had the check.
Oh, that's a quagmire.
Maybe why it was never addressed in the underlying statute.
and why relinquishment has been problematic from an Alberta Act.
Yeah, right.
That's the way it's.
So if we're not able, I want to be hopeful here, but hypothetically, if we're not able to resolve the question of what happens with property that is left with a third party. I mean, there's still other parts of this that are that still need to be considered in terms of like adding the HERPOs to this. But I mean, this is largely the third parties.
Yeah.
Well, law enforcement agencies too.
And law enforcement, right?
Yeah, right. The ads.
And wait, does it include, does it add FFLs? Is that?
FFLs, I think it adds some specific process, but FFLs are under the law.
Okay.
Same with the agencies. They can also start, but it just adds an attempt to create a consistent process when those folks will hold the same amount.
Will the court document show like what all the guns are and weapons? Will that be like a list on the court document, like X, Y, and Z gun? Because I'm
I
thinking,
don't know if that's listed in here, but
I'm thinking ahead to third party holds it, defendant goes wherever and never takes the guns back. And now this third party has them, can't get a hold of them, provides a notice to the last address. And they originally have that court document that says, you know, Joe Schmo is third party holding them. Could they take that court document to an FFL if they wanted to sell those firearms? Is that proof enough that it's now your ownership? After all the trying to get a hold of the defendant and you don't.
Yeah.
Would that be?
If the third party is doing that.
Yeah, would that be proof enough to be able to either they're now mine or I'm selling them to somebody else? Going.
I don't think so. I know there are laws that speak to at what point in time does property that gets left behind, this is a largely land tenant law actually, but at what point does it become somebody else's property because it's been abandoned for so long and the person who's possessing it has made attempts but it's a question that we don't quite have the answer to, but yeah, I mean, I think there are some important parts of this that I think need to continue moving forward, but I think there are a number of questions that need to be addressed, the third party aspect of this entirely. Maybe we can get to that answer, but that will require some more testing. Eric, is the rest of this basically the statewide model policy or?
Yes.
Yeah, okay. So in the interest of time, I do want to make sure Senator Norris has the opportunity. But I will say for 329, I'm going to see if Judge Zone can come in to speak on this sooner rather than later. And then I would like to have this, if the committee is okay with it, and have the 329. But I think there's a number of pieces that we have to work on before. Yeah, I think there's a number of pieces that we have to work on regarding the amendment for the. Is there any general opposition to that, or are we okay with attaching it, continuing to work on it?
No, I think it's a process that needs to be worked on, yeah.
Okay. All right, great, thank you. So, Senator Norris.
Yes, this is, I'll have Eric go through basically this just, is an attempt to address, also the Matos I mentioned the other day. Transfer of firearm, purchased by an individual to a dealer, and if in fact has to be shipped with FFL, the individual goes to FFL to pick it up. If it exceeds 3 days in the mail, they still have to go and get their background check done, but 3 days is basically waived due to the fact that I remember when we discussed this, 3 days basically pertain to a cooling down period. You know, someone who was a straw or whatever else, going to a gun shop, ordering a gun, buying a gun, and then committing some heinous crime with it. So this, I think the 3 day cooling period would be more than met if in fact they're going to show up with a receipt and it's not going to sell it down to the line without giving it, because payments has to be made, so on and so forth. So all this does basically just simply allows that 3 day waiting period, cooling down period to happen during that training for the dealer and the FFL. I believe those are the only changes that are in there.
That did, you described it exactly, Senator Norris. The idea is that generally speaking,
It was, and then so stolen. I mentioned him from the very beginning. If I'm wrong, he just does such a nice job with it. I always call him Ledge Council Senator.
Just taking a quick step back, I did ask to see if Judge Zone can tomorrow. He's going to be here for another bill, but to see if he can speak on the amendment that we were just talking about. So just want to make sure that's on the record.
but I do have one question about Senator Matos' amendment.
Do I have to answer?
Does it start from the day that you purchase the gun, or say you go in 12 o'clock midday and purchase the gun?
or are you talking about an in-person purchase now? Or are you talking?
No, ordering online.
Okay.
It's day one, start when the date that you purchased the gun?
Yes.
Okay.
So that was actually something that I was thinking through, so when I was going to drafting, I originally drafted it as, so it's phrased slightly differently. That, the period that the firearm is in the mail, shall be included for purposes of computing the 72 hours. But then thinking it through, about it, sort of became, clear that computing, like, well, when is it actually in the mail? Is it in, how do you know? That would be hard to, in some cases, it might be difficult to figure out when that period would get started. Because someone's like, well, I put the order with Federal Express, but they didn't actually put it in the mail till the next day. Who knows how that happens? I don't know. So it was phrased, so the conclusion was phrased it differently. You could come up with a definitive starting point, and that starting point, as you just said, the senator's office, is when the order is placed. So when the order is placed, the 72-hour clock starts ticking. If it doesn't get to you till, doesn't get to the, say you pick it up at the FFL 4 days later, then you can bring it home with you right then, because you've already got through the 72 hours waiting. On the other hand, maybe they overnight it.
Well, you have to have a background check complete.
Oh, sorry, after the background check.
Yeah.
Yes,
Right.
and all it's, they still have to have the background check.
Yeah, yeah. Right.
Senator.
So I don't think this is a crazy idea. It does satisfy, as Senator Morris points out, the basic reason for the waiting period. Where I struggle a little bit is with documentation of the data. So the way it is now, it's a very uniform system wherever you go. So you start the background check process and the clock starts. And then 72 hours later, the clock stops. If the background check is complete, you get the weapon. But here, we're allowing individuals to bring in different kinds of documentation. So somebody has a smudged receipt, somebody has a handwritten receipt. Somebody says, I don't have a receipt, but I have a picture. Somebody says, it's on my phone. Just doesn't seem like there's any uniform quality to what FFL are going to be taking in. And then my second question would be, is there any provision where the FFL has to register or keep an accounting of these documents that show the date? In other words, I think all FFLs are outstanding people running, fine operations, but let's imagine one who didn't believe in the 72-hour waiting period. And people came in and he said, you showed me a document, okay? The person is like, yeah, I showed you a document. And then he gives them the weapon. Then, is there any record keeping that's required or anything that could be audited? Because it seems like we're opening a loophole here that if it were abused, could undermine a purpose. So in other words, I'm the FFL dealer, somebody comes in and they say, I ordered it 4 days ago, but their documentation is of all different sorts. Some that looks very official, some that doesn't look official. We're putting the FFLs in charge of making those judgment calls, which
I was just gonna say, couldn't you just take the tracking number off the package and pull that up?
if that's what they have.
Well, usually it's delivered to the FFL, or would be delivered to the FFL. So there'd be a tracking number on that package. And you would have a receipt from whoever's buying it. And then you could also take that tracking number, UPS.com. Oh, yeah, I saw it came out of
Well, what if it's
wherever.
Yes. What if it's somebody somewhere just mails it without a tracking?
If I might add, I would think that a licensed firearm dealer, if they're gonna send it to the FFL of that person's choosing, there's gonna be some communication between that dealer and the FFL license holder in the state of Vermont. So they should have that information to begin with. I need to show up, say this is who I am, should have the information, let's do my background check, let it go. I don't think they're gonna run off the information, someone bring it on the phone, say, I bought a gun, here it is. I think the FFL and the dealer would have, they gotta know where to ship it.
Yeah,
So that information's gotta be on that phone.
but it wouldn't have to be FFL to FFL. It could be a gun manufacturer online.
Shipping to that FFL.
Right. But with maybe different documentation, different things that are listed. Maybe it doesn't include the date of the purchase.
I can't imagine that it won't. I can go as far as say maybe not the time, but I can.
Yeah.
Date of purchase and photo.
I guess what I'm saying is, it's hard for me to imagine any other situation where we have a legal prohibition and then you can get out of it with any kind of receipt that shows you supposedly bought a weapon on this day as opposed to that.
I'm wondering if there is any type of more specific language that can be used rather than documentation, if it was receipts or, I mean, I've never ordered something online and not gotten an email receipt that showed the date, time, or purpose, and then usually a follow-up email when it's with date and tracking number and all of that. So I maybe, because it sounds like what you're taking, what you're concerned with is the sort of vagueness of documentation.
Yes.
And so I'm wondering if there's a tighter way we could sort of
Yeah, and it
describe
seems,
that.
since we're talking about firearms, it seems like we should have something that's uniform. Right now, the process is uniform. You know, the FFL starts the clock, but now we're talking about a private seller potentially starting a clock. That would be another thing. What happens if a person buys a gun online from an individual who sends it to an FFL? So I just think I'm not necessarily against the thrust of what this is trying to do. It just seems to me to take it into an area where requiring FFLs to make judgment calls about when the provisional law has been satisfied.
I guess my question, I mean, I agree with this underlying concept, and I want to make it a bit more clear regarding the documentation piece, and not necessarily making it the purchaser who has the power of being able to come in with like a smart receipt or some picture on their cell phone and say, you know, this is when I bought this gun. If there's a way to make it so that an FFL independently can verify that something has been granted for at least 3 days from the date of purchase, then I think that would make sense. And I think that could get away from any of attempts of fraud in an individual purchaser trying to circumvent the subject well agreement. And I think another question that needs to be confirmed is, what are the federal guidelines for mailing a firearm through the mail? I feel like it's not like sending a postcard. I feel like there's making assumptions here, but I feel like there's got to be some laws around tracking. If you're putting
Insuring or,
yeah.
could be plenty of that.
I mean, whenever you go to the post office, they always ask you if you have anything, hazardous, or whatever, before you mail it. So I think that's something that we need to clarify. And if there's a way that, if something is being legally shipped and under the assumption that federal guidelines require a tracking number of the firearm that are mailed, and the FFL has the ability to independently verify that something's been in transit for at least 3 days.
Yeah.
Then I think we're getting to a place that's a bit more secure than a purchaser coming in with documentation.
Yeah, because when you ship alcohol, you have to show an ID or take receipt, right? So you can't show any ID, you have to show government issued ID. So it's uniform, right? But if you could show any kind of documentation of your age, you'd run into the same problem. So I'm sympathetic to the underlying intent here. And I think with maybe some digging, we can find a way to make sure that the date and the proof of the date is uniform or relatively uniform. But yeah, I'm just thinking about somebody really wants a gun, they go into an FFL with some receipt that the FFL doesn't really like. They get into an argument with the person, and that argument is our fault.
Yeah, I was gonna just quickly add that I would also want to make it clear for the FFL that if they don't feel that whatever tracking number they're looking at is reliable, or rather if there's a tracking number that's unavailable through, whatever postal system, they don't have to, avoid the 72-hour waiting period. If somebody comes in and says, just go here and look at the tracking number, like the law says, but they can't find it, the FFL can still say, we're still waiting 72 hours. So,
Yeah.
Senator Mandos, you had,
No, I was just kind of thinking along those same lines that at the end of the day, it's kind of like refusing to sell alcohol.
Yeah.
Hold that, as an FFL, say the same thing. Hey, and something seems fishy out of place.
Yeah.
You gotta wait 72 hours.
Yeah, and you're not denying the person the weapon, ultimately, you're saying, I'm more comfortable if we go through the normal 72 hours.
Or the person you're purchasing it off of, they can be like, hey, I ship via this service that doesn't provide it. You know full well, now I gotta wait 72 hours since FFL verified.
Yeah, there's a question about the documentation. Yes, proceed with the background check like you can do anyways. So I don't expect that to throw themselves under the gauntlet here just because.
Yeah,
they're set
and I think there's a way to get there with this. Maybe we just don't know quite enough about how firearms are shipped, like you're saying.
I think, Henry, can you reach out to Henry Perro? It's Henry, right? Henry. Can you reach out to Henry Perro and see if he has availability to by this week on these questions? And with Friday being the most available, but if he's not available Friday, then we could try to find some flexibility here of it is. Okay, thanks. Anything else committed? All right, so we'll hear from Judge Zonig, we'll hear from Henry Perro, hopefully. Keep moving along. All right. Perry, do you mind if we take 5 minutes?
No.
Great. All right, so we'll go offline for
Nobody